You tried everything. You tried to negotiate, tried to mediate, you tried lawyers' letters, nothing worked. And now you're in a dispute with the person. You're in court. You might be in the federal court. You might be in the Supreme Court. Common issues like being locked out of bank account or systems, board meetings happening without notice or without the person involved, no access to financial records, no dividends despite profits or money flowing to related parties, sudden removal from directorship or employment. Um, these are often things that we see happening that may not be capable of being mediated or negotiated, and inevitably they're destined for litigation, unfortunately, because of the nature, the severity of what's going on.
That's quite right. And at that stage, once things start to become litigated, I can't emphasize enough the importance of getting the pleadings right. While there is a right to amend pleadings at least the first time around, and leave can be sought to amend pleadings subsequent to that, nevertheless, it's often the case that litigation will get so far as the courtroom before the parties realize that actually we should have made a claim under a different provision entirely, or perhaps made a claim in the alternative. Just by way of example, a proceeding could be brought on the basis of a procedural irregularity under Section 1322 of the Corporations Act, or it might be a statutory derivative action under Section 236, or a party might seek a statutory injunction under Section 1324, or a shareholder oppression claim, as I mentioned before, under Section 232. There's even an application to wind up a company under 461 if the company has ended up in a deadlock type situation. And it's really unfortunate when the parties get to the end of a litigative process and then realize, well, they brought this claim under Section 1324, but really, perhaps in hindsight, they ought to have brought a claim under Section 236, and that's now foreclosed to them because they never pled it. And so having good legal advice right at the start of the litigation process is really critical.
That's right. Choose your causes of action wisely. Keep things simple. You don't need to plead everything under the sun. Often you come to a lawyer, you've probably got maybe 10 or 20 even pathways you can go, different causes of action. But the one thing courts hate is when you start pleading everything under the sun. You don't need to. Your job as a lawyer is to find the best, simplest, fastest way forward, but the right one. So it's a skill. It's something you learn from experience, something you learn from improving your knowledge. So certainly, like I said, getting yourself the right lawyer that understands that area of law. So I talk about looking at your lawyers and legal fees as an investment. It's a difficult sell to give to people, but we've got to try because ultimately that's going to be what might end up saving them a lot more money down the line.
That's quite right, and it's really unfortunate when clients end up in heated litigation that could have potentially been avoided by getting legal advice on the sunny days, rather than avoiding that expense and then suddenly finding that they now have to spend a whole lot of money dealing with a long, protracted litigation process that is not just expensive, but it's emotionally draining, and it distracts from the work that the parties are trying to engage in. If you've got directors who are engaged in litigation, well, they're unable to manage the company because their focus is elsewhere. And if you've got shareholders who are engaged in litigation, that means that their money is tied up in that investment that perhaps they ought to have taken it out and moved elsewhere, but now they can't because it's all tied up in this dispute. So that's why it is really an investment to make sure that one obtains the right legal advice at the right time, so as to not find these issues biting you in the butt later on.
Yeah, that's when you need to say, this is now more than a personality clash. This is a legal dispute potentially, but try and recognize it early and prepare yourself as best you can, quietly, gathering your documents, your evidence, your information, your rights, your legal advice, have them all at hand, understand them. I remember recently that I had an issue with two directors in disputes about, you know, all sorts of things. The list went on. They were in business for about 10 years, and they basically had just come to the point where they couldn't work together anymore. And there was actually a shareholders agreement in place because they were the shareholders as well. And it had buyout mechanisms, and effectively one of the directors didn't want to follow that clause in the agreement. So we actually ended up having to bring it before the court. We ended up in the federal court, and effectively the court decided that the agreement was signed, it was agreed to. There's a lot of emphasis placed on people signing legal documents in the absence of any sort of capacity or disability issues. And, the parties are going to be held to the contract and the agreement they signed. And in that situation, effectively, it was ordered that that the court would then make sure that the parties perform the agreement in accordance with its terms and conditions. So that was a really good result. And we got it done in a very short period of time. We actually applied to the court and then applied for summary judgment afterwards because there really was little to no prospects of success on the other side defending it. So that was a really good outcome. And that's the importance of not just commencing the case, but then assessing the case for interlocutory processes. So if you can bring the proceeding to an end early, you should do so. As a lawyer, you should give that advice to the client. Whether they want to invest in that or not is up to them, but certainly could be a fast way forward.